Welcome to S&C's podcast series, S&C Critical Insights. My name is Jeff Scott. I'm a partner in S&C's litigation group and co-head of our securities litigation practice. I'm joined today by my partner, Julia Malkina, who is also co-head of our securities litigation practice and a partner in the firm's Supreme Court and appellate practice. Today, we'll discuss the upcoming oral argument in the Supreme Court in the NVIDIA Corp versus Oman case and the potential implications for company securities litigation exposure. Julia, why don't you give our listeners a brief overview of what we'll discuss today?
Of course, Jeff. I'd be happy to. On November 13th, the Supreme Court will hear oral argument in the NVIDIA case. There are two issues before the court. First, whether plaintiffs seeking to allege scienter under the Private Securities Litigation Reform Act, known as the PSLRA, based on allegations about internal company documents, must plead with particularity the content of those documents. Under the securities laws, scienter is fraudulent intent. As we'll discuss in just a moment, the scienter is an element of the securities fraud claim that plaintiffs were seeking to prove in this case. The second issue presented in the NVIDIA case is whether plaintiffs can satisfy the PSLRA's falsity requirement by relying on an expert opinion rather than particularized allegations of fact. Falsity is another element of the securities fraud claim that plaintiffs asserted in this case. And the question is whether they can proceed past the pleading stage based on an expert opinion that the defendant's statements were false, rather than having to plead particular facts showing more directly that the statements were false. We'll first talk a bit about the background of the case, and then summarize the key issues and arguments that the Supreme Court will consider. Finally, we'll turn to the case's implications with respect to both issues it presents. So let's start with some background. Jeff, what do we need to know to understand the questions presented?
Thanks, Julia. The questions presented relate to the pleading requirements for a securities fraud claim under Section 10B of the Securities Exchange Act of 1934 and Rule 10b-5. This all might sound familiar if you tuned into our podcast last week about the Supreme Court case Facebook versus Amalgamated Bank, which also concerned liability under Section 10B and Rule 10b-5. By the Supreme Court's customary standards, this is shaping up to be a securities-heavy term. Typically, the court might take one case, maybe two, about securities law during a term. But we already have two securities cases at the beginning of this term, and there could be more to come. And as you mentioned, NVIDIA presents two distinct issues, each of which is quite different from the one in Facebook. Thus, the Supreme Court will be covering a great deal of securities law ground this term. This is very exciting for us securities law junkies. Julia, are there any commonalities between the Facebook and NVIDIA cases?
Yes. One commonality between the two cases is that they both concern Section 10B and Rule 10b-5. For the benefit of anyone who did not join our conversation about the Facebook case, a private plaintiff seeking to prove liability under Section 10B and Rule 10b-5 must prove 6 elements. First, a material misrepresentation or omission by the defendant. Second, scienter. Third, a connection between the misrepresentation or omission and the purchase or sale of a security. Fourth, reliance upon the misrepresentation or omission. Fifth, economic loss. And sixth, loss causation. This case concerns the first two elements. What must the plaintiff plead and ultimately prove to show that the company or employee's statement was a misrepresentation? And what must the plaintiff plead and prove to show scienter?
Shareholder complaints alleging securities fraud are subject to the PSLRA's heightened pleading requirements. Plaintiffs must state with particularity all facts supporting their allegations of falsity, and must also allege facts giving rise to a strong inference of the required mental state. In essence, the plaintiffs must state with particularity the facts supporting the falsity of the defendant's statement, as well as facts giving rise to a strong inference that the defendant acted with scienter. A strong inference in this context means an inference that is at least as strong as any opposing inference. In other words, plaintiffs must plead facts that render the inference that the defendant knew the offending statements were false at least as likely as any inference that the defendant did not have such knowledge. This standard is more rigorous than the typical pleading standard that applies generally to civil actions in federal court, which asks only whether there is a plausible inference of wrongdoing. So it's important to note that the Supreme Court's decision in this case will apply only to litigation under the PSLRA. Julia, could you please walk us through some of the background about how NVIDIA ended up at the Supreme Court?
Certainly, Jeff. NVIDIA is a tech company that sells computer chips, and the factual issue in this case turns on the extent to which NVIDIA sale graphics processing units, or GPUs, were driven by demand related to cryptocurrency or demand related to gaming. GPUs have many functionalities. As relevant to this case, they can be used both in crypto and in gaming. Yes, as in video games. Crypto can at times be volatile. As a result, although NVIDIA was experiencing tremendous success in 2017 and 2018, investors were interested in the extent to which NVIDIA's success depended on the crypto market. The question was, were NVIDIA's impressive GPU sales driven by cryptocurrency miners or by gamers? Plaintiffs allege that NVIDIA executives and employees generally answered that NVIDIA's exposure to crypto was limited. NVIDIA started to encounter some headwinds in the second half of 2018, and it missed its revenue projections and began projecting a revenue decline. NVIDIA's co-founder and CEO, who is a defendant in this case, attributed those changes to what he called crypto hangover. In the 2 trading days following that remark, NVIDIA's stock dropped by 28.5%. Predictably, this putative securities class action suit was filed, alleging that NVIDIA and its executives had known and concealed the extent to which the company's GPU sales were driven by sales to cryptocurrency miners as opposed to gamers. As relevant here, plaintiffs are required to plead with particularity 2 sets of allegations. First, that NVIDIA's sales were in fact driven by crypto demand to a greater degree than its executives publicly stated. And second, that defendants knew those statements were false at the time they were made. Jeff, how did the plaintiffs try to plead falsity here?
The interesting fact here is that the plaintiffs relied principally on a report by an expert economic consulting firm they retained called Prism, which asserted that NVIDIA had understated its crypto-related GPU sales by about $1.13 billion in a 15-month period. That was consistent with a similar analysis that Royal Bank of Canada, or RBC, did independent of this case. And RBC concluded that NVIDIA understated its crypto revenue by about $1.35 billion in an 18-month period. To try to plead scienter, plaintiffs relied on accounts of purported former employees who said NVIDIA kept detailed records of who was buying its GPUs and that its CEO personally reviewed sales data and reports. Critically, the plaintiffs did not plead with particularity the contents of these reports. They argued that the allegations about the report's preparation coupled with allegations about what they would have shown in light of their other allegations that NVIDIA was in fact heavily dependent on crypto-related sales, suffice to plead that defendants knew that their statements minimizing the company's crypto exposure were false. Julia, how did the Ninth Circuit rule here?
So the Ninth Circuit ultimately agreed that these allegations sufficed with respect to both falsity and scienter. Over a dissent from Judge Sanchez, the panel majority held that Prism's expert report, bolstered by RBC's independent report, was sufficient to plead falsity. The majority expressed the view that there was no basis for Judge Sanchez's reasoning that falsity cannot be demonstrated by outside experts alone. The majority further held that even though plaintiffs did not plead the contents of the internal documents on which they relied, their allegations taken as a whole were sufficient to plead scienter. The panel majority specifically noted that, in their view, a CEO would be expected to know the source of more than $1 billion of his company's revenue. So the majority reasoned that to the extent the allegations suffice to plead falsity, in other words, to show that there was in fact a large amount of crypto revenue, they also tended to show scienter, including because of the internal reports plaintiffs alleged the CEO had seen.
Thanks, Julia. As we know, the Supreme Court agreed to hear both issues that we've discussed so far. First, whether expert opinions may substitute for particularized factual allegations of falsity. And second, whether reliance on internal documents for pleading scienter requires alleging the contents of those documents that put defendants on notice of the purported falsity of the statements. Plaintiffs essentially argue to the Supreme Court that NVIDIA is seeking to impose bright-line rules that are unsupported by the text of the PSLRA. According to the plaintiffs, the PSLRA does not require that the contents of internal documents be pleaded specifically if they are to be relied on, nor does the PSLRA prescribe a rule that expert opinions cannot be used to plead the falsity of certain statements. In short, plaintiffs accuse NVIDIA of trying to create not one, but two atextual rules. Of course, NVIDIA strongly resists plaintiffs' characterization of its arguments. NVIDIA says that the requirement to plead specific contents of internal documents comes directly from the PSLRA's particularity requirement, and NVIDIA says further that disfavoring expert opinions comes from the statutory requirement that a plaintiff plead facts, and expert opinions are not, of course, facts. Whether the Supreme Court agrees that NVIDIA's proposed rules of law fall from the text of the PSLRA will go a long way towards determining whether it wins this case. Julia, with that high-level overview of the arguments in mind, let's discuss each issue in turn, starting with the pleading requirement for the contents of internal documents.
Absolutely, Jeff. On this issue, a lot will turn on whether the Supreme Court accepts that the PSLRA's particularity requirement requires that contents of internal documents be pleaded specifically. NVIDIA argues that pleading facts supporting scienter with particularity requires that when an internal document is the evidence for scienter, the actual contents of the document must be pled. Otherwise, the allegations are too vague to meet the pleading standard. Plaintiffs argue that the Supreme Court's PSLRA cases have repeatedly said that bright-line rules should be avoided, and NVIDIA is transgressing that warning. NVIDIA will have an easier time if the court accepts, as it should, that this rule is merely the result of the PSLRA's textual requirement that scienter be pleaded with particularity. Conversely, plaintiffs rely principally on a case called Telelabs. They argue that Telelabs explained that a court's job is not to assess whether any single allegation is sufficient to support a strong inference of scienter, but instead to assess whether the allegations taken as a whole support a strong inference of scienter. Plaintiffs then say that this supports avoiding bright line rules. Now, whatever the merits of that argument, one issue for plaintiffs in this case is that they don't have many other allegations to help them create a strong inference of scienter.
Julia, it's my view that NVIDIA offers some concrete reasons why it's important for the contents of the documents to be alleged specifically in the context of this case. In particular, the users of NVIDIA's GPUs, whether gamers or miners, were often downstream third parties, not the initial buyers of the GPUs. Consequently, it's important to know whether these internal documents address the GPU's end users or only the initial buyers. The parties also advance arguments that might be described as sounding more in the policy or purpose of the PSLRA. Specifically, NVIDIA argues that if alleging what internal documents would have or must have said satisfies the pleading standards, companies will be overexposed to precisely the kind of frivolous litigation that Congress enacted the PSLRA to thwart. After all, anyone can make such allegations about any public company.
Plaintiffs, in turn, argue that leniency with respect to the content of internal reports and records is appropriate because this is a type of evidence that is difficult for plaintiffs to obtain prior to discovery. As we discussed last week in our episode on the Facebook case, the Supreme Court often does not place significant emphasis on these sorts of policy arguments. But if it does, the court may consider these policy arguments through the prism of the PSLRA's text, such as the clear textual purpose of requiring particularized pleading, regardless of whether that leads to difficulties for plaintiffs' claims. Why don't we turn to the second issue, Jeff?
The second issue, Julia, is the extent to which a plaintiff may rely on expert reports to plead falsity. As a refresher, plaintiffs here tried to plead that NVIDIA was in fact more exposed to crypto than it disclosed through two reports by RBC and Prism, the latter of which plaintiffs hired to give an expert opinion in this case. NVIDIA also argues that an expert's opinions cannot count toward the quantum of facts a plaintiff must allege to meet its pleading burdens under the PSLRA. According to NVIDIA, at the pleading stage, a court must strip the expert report of all opinions and review only the facts upon which the opinions are based, and then decide in that position whether those remaining facts are sufficient to state a claim under the PSLRA's heightened pleading standards. Julia, what's your take on this issue?
Parties devote less attention to this issue in their briefs, and it's worth noting that the Supreme Court may not decide this issue at all. If the court determines that plaintiffs failed to plead scienter because their allegations about NVIDIA's internal reports were too conclusory or vague, that could be the end of the case. The court would not need to address whether the plaintiff sufficiently pleaded falsity. But of course, it could do so if it would like to. Putting that point aside, a difficulty for plaintiffs is that the PSLRA's text specifically requires pleading quote-unquote facts. That said, a potential challenge for NVIDIA is the distinction between an expert's opinions, which NVIDIA says are unusable to establish falsity, and the underlying facts, which NVIDIA argues are appropriate to use to establish falsity. That distinction, in practice, may not be as clean as it sounds on paper. So the court may hear a number of textual arguments from NVIDIA and some workability arguments from plaintiffs.
I agree with that, Julia. This is one of those cases where I'll be listening to the oral argument very closely in part just to ascertain the parties' respective positions. We may hear a lot of clarifying questions from the justices, trying to understand what sorts of expert opinions NVIDIA thinks must be excluded in assessing the sufficiency of falsity allegations. So, Julia, what are the implications of how the Supreme Court could decide this case?
That is, of course, always the question, Jeff. The outcome of this case is especially difficult to predict because there are many different ways the Supreme Court could resolve it, some broader, some narrower. For example, if the Supreme Court were to hold that a plaintiff relying on internal documents must always plead the contents of those documents with particularity based on the PSLRA's requirement that scienter be pled with particularity, that would be more significant than some of the other potential outcomes. It would not allow plaintiffs to merely guess or assume what documents could have or might have contained. The court also could rule more narrowly in a manner that is more fact-dependent. It could, for example, say that internal documents whose contents aren't pleaded with particularity count for little, even if not nothing. But because there are no other scienter allegations in this case that are worth crediting, the case must be dismissed. That would leave open for future cases whether internal documents whose content is not specifically pleaded could add to other scienter allegations that are pleaded with particularity in a holistic assessment of scienter. Of course, the court could also rule in plaintiff's favor on this question. Plaintiffs would argue that such a holding lowers the bar for pleading scienter, but I think this is the least likely of the potential outcomes. How about on the second question, Jeff?
Thanks, Julia. Here, the Supreme Court may issue important guidance about the extent to which experts can be relied upon to get past the pleading stage in PSLRA cases. That said, while it certainly happens, it's not that often that plaintiffs try to offer expert evidence, at least in the form of hired experts like PRISM, at the pleading stage. As with the first question, though, the implications could vary significantly, in my opinion, depending on how broadly or narrowly the Supreme Court rules regarding permissible uses of expert opinions. There are also second-order implications here in terms of whether the Supreme Court can prescribe clear rules and guidelines in answering this question. As noted a few minutes ago, there are practical challenges in answering the question, including what counts as opinion. It could be difficult to explain the rule or prescribe it in a way that lower courts can follow.
I think that's right, Jack. It's also worth noting that the implications on this issue could be zero if the Supreme Court simply does not decide it in the first place because it has disposed of the case on scienter grounds.
Indeed, Julia. Any final thoughts for our listeners, including when we can expect to receive a decision from the High Court?
The Supreme Court is expected to decide the case during its current term, which typically ends in late June. So we should expect a result by June 2025. The case is being argued early in the term, however, so it's certainly possible that the court will decide it well before then.
Well, thank you very much, Julia. And I'll look forward to hearing your thoughts on the Supreme Court's decision in this case when it's released. Well, everyone, that's all we have for today. Thank you for joining Julia and me for this installment of S&C's Critical Insights. For more information about our practice, you can visit us at www.solcrom.com. Thank you very much.